So, welcome everybody. Welcome to today's interview in the frame of our CESI Talks series. Today we are with Professor Paul Schoukens, Professor of Social Security Law at the KU Leuven. And Professor Schoukens is also chairman of the Department of Labor and Social Security Law, and has been, I think this is quite an important also detail, Secretary General of the European Institute of Social Security. Professor Schoukens, welcome.
Thank you.
We met online a couple of months ago, maybe already half a year ago. We spoke about the European Pillar of Social Rights on 4th of March, if I'm not mistaken. The so-called action plan has been published. Where are we standing according to you?
Well, that's, I think the emphasis is indeed on launched. I think many of the plans of activities have been launched also in the broader sense, also on platform work and the revision of the social scoreboard. And if you see what is being planned for the coming years, the initiative on collective bargaining, if that's being done properly, normally it will also be scheduled for the last part of 2021 to come to a kind of approach there. So I think in launching and in planning, I think we are still very much in line with the schedule. If for instance, I look at the recommendation, well, Principle 12, there are many of the member states, or the member states have been introducing their reports and the Commission, and I think if everything goes well, will launch in November there the monitoring. So it's very hard to say that we are standing, unless to say that even though we had COVID and Corona, the plans are being launched. But what I think will be interesting to see is the coming months, to what extent the EU, but especially the national governments, will be committed to the activities. And if I fall back again upon, for instance, the recommendation, I really look forward to see how serious this has been taken up by the countries. I understood that some member states introduced a very extensive report on the problems they face with access to social protection, especially for the non-standard workers and self-employed, and possibly others not. And then also in the follow-up of that. Of those reports and what will come out of the EU itself. For instance, the social scoreboard has been a new or an improved scoreboard has been proposed, but so far it has not been used in the JEPIAs, in the Joint Employment Report, or the country-specific recommendations of 2021, mainly because of COVID. That remains to be seen. So I think the coming months will be interesting to see, first of all, how the EU will apply its own instruments in a consistent way, because apart from the national states, I hope what will not happen is that we end up with pillars in the approach. That on one thing you have the economic financial monitoring, and on the other hand you have the social story, and that those still live next to each other. That's one of the weaknesses we had in the last years, if not to say decades. It should be integrated, and I hope that some of the well, let's say the advices, recommendations, or rules will find their way also in the more economic financial monitoring or in the country-specific recommendations, and that in a very consistent way use is made of all the initiatives which have been taken in the past. So I think, I mean, like, as to the programming, it's very difficult to say many things, but it's I'm very much eager to see how committed the states will support the initiatives. And of course, we have some upcoming elections in some countries. We had some major elections in Germany. This may also have, of course, an impact, I think, in the medium short term.
Professor Schoukens, the EU Social Security Coordination topic has been already over 60 years old, if I'm correct.
Yes.
And it is of such complexity that sometimes I do not envy those who are trying to reform it. But where are we at the moment with the reform or revision of the regulation of the 883, I think, regulation? What is the most urgent for you now to happen in order to make sure, when I recall the aim of was that persons moving within the EU do not suffer losses in terms of social security rights and benefits? What should happen?
Well, in the very short term, I hope that they come to an agreement on the proposal for adaptation. That's already hanging some presidencies. If they don't manage now to have it implemented, I think it sounds a bit strange, but now or never. I don't know if they don't manage to do it now, then what will happen. But in a more broader perspective, I think work mobility has the character of work mobility changed again. So it's already for decades that mobility is much higher than, let's say, in the beginning of the 1950s and 60s. The instrument was designed for the traditional migrant worker moving for one time from Italy to Germany, working then in the industry, and then possibly going back to the home country. That was the original migrant for whom that regulation was being designed. And then we got that higher mobility, posting of workers. People start to combine activities. They work in different countries. You have the transportation workers. It's astonishing to see that the transportation article was removed in 2004, but then gradually being introduced again for categories of transportation workers, because we noticed that the basic rule, lex loci laboris, was hard to apply for those highly mobile workers. In my own sector research, I see also very high mobility, and I see that the coordination regulation is not always easily applicable. And then you had platform work, where mobility becomes virtual. But I think with Corona and COVID-19, we have telework more and more. Telework was something already in place for many years, and the approach of the court was traditionally, well, telework is something marginal in the broader setting of work. So people can work, for instance, at home for a day, but you don't have to take that into account to change the lex loci laboris. So we still connect to the main country, and the marginal activity at home is not to be taken into account. That was a bit the position. And up till today, we have a very little interpretation of that regulation there, where you physically stand to work. That's indicating the competent state. And I don't think this can be upheld no longer with telework, with COVID. I mean, now you feel COVID-19 probably will have an impact that wage earners will go to kind of mixture of working at the premises and working partially at home. But if my home is in another country, then of course this can have a consequence of change of competent country to the home country. And is that the whole idea? So I think the concept, where do people work, will need a further interpretation, and the physical link. And so there, where you're physically standing to work, I think we have to come to a broader interpretation. Probably it will be there where you normally work, and then if you connect it with your work through a virtual link, or when it has to do with the same work of your normal workplace at home, that will be linked to your workplace or something. But they will have to be very clear, because now they make unilateral or bilateral arrangements where they say that the homework is considered to be as if you're working still in the other country. But this is applied in a very strange way, possibly also against the will of the worker, and this cannot be possible. So there, I think the Corona may also be a game changer in that respect, and push that discussion a bit further than, let's say, some years ago, where it was already felt necessary to have a reconsideration of the competent state rules. I think we are at the verge of a further fundamental discussion on that. It's possible that maybe residents will become more relevant, I don't know, but I think first and foremost, where do people work has to be reinterpreted, and also from a national law perspective, by the way. It's also for national systems. I mean, Bismarckian systems, we will have to deal differently with it, because more and more workers will combine working at the premises with working at home.
Interesting and challenging time. You mentioned some the already fragmentation which take already place, and the disruptions. If we think of social security, and we think of digitalization, which is some kind of catalyst also, let's say, to these fragmentation and disruptions. Where do you see possibilities to use digitalization in order to achieve, could I say, more seamless social protection for all workers?
I think there's a potential application for control and checks, and they're moving already in the direction with the card, the pass, European Social Security pass. If I see a digitalization in coordination, I mean, we first had that whole movement of the AC, but to be very honest, I think it was a far too conservative translation of paper forms into digital forms to cut a short very bend very short, I would dare to say that one has been simply re-uploading the paper forms into digital forms, which of course makes things more fast and easy. And as soon as administrations will comprehensively work with it, it will speed up processes, and I'm certainly not against it. But digital tools have more potential than paper forms. And that's something I think there was an opportunity missed. And you can also with applications, apps, or smartphones, you can use more to check and control things if you really want. And now I think they're moving slowly to that path. We're using that for an A1. Possibly in longer term, all the certificates or more certificates can be introduced, and it can help better control and check of workforce, and to see whether they're really socially protected and they have been they are in line with the rules of the regulation and so on. But still, I think more could be done, and I think people working in the IT, I'm not an IT expert, but people working in the IT sector say that those tools can do more than one is doing right now. For instance, it can also bring in record your work record across the countries in a year, for instance, and that could also be used for to decide where to apply which social security system, to control things. If I see the very frustrating situations where administrations sometimes have to work in, where they of course have to respect the certificates from another country, and I do understand that the court is very much sticking to that, because otherwise you cannot have a European Union anymore. But by diligently asking first information and waiting, you lose a little bit of the momentum for control. And I think better use of applications could be even more helpful than the past. Again, I'm not an IT expert, but I think there is more potential there to be used. What I don't like is that the whole story of free movement of workers and posting very often is being approached from the fraud aspect and the abuse aspect, and it was not intended for that. It serves a purpose, both free movement of workers, the coordination regulation, and also the exception of the posting. But indeed, there are some sectors where you see that it's completely wrongly used and abused, and we really have to address it. And there, I think the path is certainly a step in the good direction, but I think we can do more there.
Professor Schaukens, a final, very brief statement. When we met, I think 3 or 4 years ago, you told me that for the first time in many, many years, maybe even decades, you were positive about a social EU. How do you see it now?
Well, actually, we had last week in Zagreb a conference on access to social protection, and you're referring to that positive element. It was, I mentioned that in relation to the EU recommendation on access to social protection. And I mean, it's simple. I mean, the reason why I was so positive is after 25 years, again, a major rule, although not enforceable, but still it was a recommendation on access, and it's a nice piece of document. There are some flaws, there are shortcomings and so on. I'm still positive. Last Friday, I've been asked the same question, whether I'm still positive about the recommendation. Yes, because there is potential to use this text, to use this advice, to use these recommendations of the Commission to redesign the system in the direction it has to be redesigned, in the sense that social protection should be accessible for all working people, regardless their way of work, regardless they're self-employed, or regardless their wage earners. And in that text, it's very nicely addressed. Now we will see whether the countries take it seriously. I think they better do so, not because there is a recommendation. Again, it's not enforceable, so they can even simply put it aside. But that's the challenge for the future. Work is changing. People are working and living differently, earning income in a different way, let's say, than 50 years ago. And if we miss this train, Social Security will end up as a kind of niche for standard workers who work from 9 to 5, have a regular income, and all the rest, which will, well, half, maybe majority, I don't know, will get outside. And then you are again back at the beginning where we started, end of the 19th century, beginning of the 20th century, that only some categories of people, the civil servants, some white-collar workers, and like also you see in developing countries, that it's very categorized, and they do all the effort to have it in a broader application. We, in most of our countries in the EU, already have that broader application, but we risk to lose it. We risk to lose it if we do not reinvent and fine-tune and align social security to those new categories. And therefore, I was positive because it was about this, and it's an invitation to the countries to take it serious. Let us hope that they take it serious. Maybe within a year I will be less positive, maybe 2 years. We'll see, but I'm still positive right now.
Let's hope for the best. Professor Schaukens, thanks a lot. Take care of yourself.
Thank you.
And see you very soon.
See you very soon. Thank you very much.
Bye. Yeah?
Bye. Bye.